is by Rachel Wood, who is going to talk about artistry again. And without further ado, Rachel, the floor is yours.
Hi, so I'm Rachel Wood, and as you can see from the slide, I'm the Business and Law Clinic Director, which is still quite a new role here at UWE. I'm involved in developing clinical education in the Faculty of Business and Law. I'm a bit conscious that my session takes more of a case study approach. It's really a more sort of personal reflection before action on the process of taking expertise in a new direction in the context of a new teaching project in law. So please bear with me. I hope that exploring some of the challenges in this practice context will throw up thoughts and reflections which can usefully be carried across into other disciplinary areas. This symposium falls at a really interesting time for us. Next week at UWE we launch a new law clinic module which is called Lawyering in Practice for our third year law undergraduates, and in November we're opening a new law clinic which will offer legal advice to the public on issues arising in employment law and family law, areas which we know are really in need at the moment in light of the current crisis, the redundancies and the pressures of lockdown. So this is the first time that we'll have taught clinic as opposed to offering it as a more informal extracurricular activity for students. And it's created an opportunity for us to really define our pedagogic approach and to reflect on the impact of teaching in a new way on our expertise as teachers and also on our professional identities as both teachers and lawyers. So I'm going to touch briefly on three connected points. Why the opportunity to shift from the traditional disciplinary way of thinking like a lawyer through a clinical approach is important to us. And I'm going to talk a bit about that disciplinary way of thinking, which feels a bit like going off topic, but bear with me. Then how we're going to enact Schön's concept of the reflective practicum in a clinical setting as we aim to move towards a pedagogic approach that's deliberately more attentive to a holistic, effective experience of lawyering for our students. And thirdly, what the implications are for us as teachers who are also acting in the role of lawyers in legal clinic in relation to our sense of artistry and expertise in this expanding conceptualisation of our teaching role. The implications of the disciplinary approach of thinking like a lawyer have been a thread which is woven through the international legal education literature in the US and Australia for the last 20 years. And it's a concept that's commonly associated with an approach to law that seeks to address legal problems using intellectual cognition, legal reasoning, rationality, and often seeing problems in an adversarial fashion. And it's a really important and powerful way of thinking for practicing lawyers. It's like a bit like somebody described it as almost like a magic trick, that thing you do as you unpack and kind of come up with a solution. In a university setting, however, it can be a much drier exercise. It fits within Schön's definition of ways of thinking that foreground technical rationality. And in law school, it's typically associated with areas of the curriculum where challenging but pre-packaged and defined legal problems are presented to students in quite a detached way. And so there can be something slightly surreal about this approach. It's connected to practice, but at the same time abstracted from the real world and the realities of legal practice. And as a teacher, this can over time create sometimes quite a safe, comfortable space to teach from, because the messiness of the law in action is contained. Schulman identified thinking like a lawyer as a signature pedagogy. In fact, Schön does as well. For Schulman, he saw it as being a miserable failure in law schools in the US, precisely because of this disconnect with legal practice. He was engaged with the project of the Carnegie Foundation, which came up with this three-stage apprenticeship model for law, where the three stages of the cognitive thinking like a lawyer stage, the practical and the moral parts of an apprenticeship were separated in the training and professional identity formation of lawyers. And the system we have here in the UK is quite different, but we can still see that running through our UK legal education structure. The degree is the cognitive stage. We then have the practice stage, which is for our would-be at postgraduate level for our would-be barristers and solicitors. And then the moral apprenticeship doesn't really kick in until people go into practice. So they're really at the whim of whatever the practice environment they are in for that part of their learning. And separating the thinking like a lawyer stage from the other two stages has been identified as a potentially negative thing for law students if it's seen as the signature pedagogy at the cost of other aspects of lawyering and other ways of thinking about law. And the literature contains a number of studies, and Hess's quote as an example. of the type of ways this is expressed in the literature, that it has a negative impact on the psychological well-being of law students. And in the UK legal education community, there's been a shift and a kind of kickback against this, which is happening at the moment. So there's much more interest at the moment in areas like emotion in the law school. So Emma Jones's from Sheffield University's recent book, Emotions in the Law School, Transforming Legal Education Through the Passions, and in formation of professional identity, which has really been under theorised in the context of law students. So Caroline Strevens at Portsmouth University and Rachel Field from Bond Law School in Australia have just published a book, Educating for Wellbeing in Law, Positive Professional Identities and Practice. So it feels as if there's really a new movement afoot in legal education, which is seeking to take a more collaborative, holistic, embodied approach to law teaching. And subjects like dispute resolution, which focusing on teaching mediation and negotiation, which is something I also teach, are growing in popularity in law schools. And this is really positive, but it requires us to enlarge our approach to expertise in teaching law in new directions, and that's potentially challenging to us as law teachers. So in the Lawyering in Practice module, we deliberately are going to aim on focusing on a shift from thinking like a lawyer to being like a lawyer, and a lawyer who's more attuned to understanding the impact of emotion, the enacting of values and ethics, and who is able to be consciously attentive to all aspects of the experience, and who are able to reflect in and on action. And we've talked a lot today about the process of Schön's process of reflection. And this sounds really obvious, but unlike other professions, teaching, social work, nursing, for example, lawyers don't have an established tradition of focusing on their development as reflective practitioners. It is a growing area of interest, particularly in clinical education, but it's not yet a fully developed aspect of legal education. So we wanted to fit these things into the new curriculum, but in addition, we want to make that approach to reflection more holistic. We want to bring together the three aspects of the professional identity apprenticeship, and we want to explore how students can, through their development of reflective practice, also recognise the human implications of engaging in legal work and the impact of that human element on their own experiences. And this is really important in legal clinic, where clients will often be vulnerable, their problems very challenging, and what we can offer quite slight as against what they need, which is not met by the legal system. And by way of example, I've got 2 queries coming today about very nasty situations of domestic abuse, which, you know, as tutors and teachers dealing with together, very, very challenging. So we see what we are doing as sitting within Schön's vision of a reflective practicum, and coming back to those initial metaphors of holding fences and muddy swamps. We are going into the swamp, Schön's swamp of practice, with our students, and the boundaries between teaching and practicing are potentially quite blurred here. My current inbox is full of queries. I've already given you a couple of examples of that swamp metaphor in action. They're random, they're unfiltered, they're sometimes desperate, and bringing those into a teaching environment is doable, but it can feel quite dangerous, and it needs to be managed very carefully. So the expertise required is significant. We require a very different form of artistry to traditional law teaching, including teaching which is practice focused. We can't be sages on the stage. We need to be absolutely side by side with our students, experiencing clinic with them, subject to many of the same emotions and concerns. So we sit, I don't, she's giving me the 2 minutes yet. No, not yet, good. We sit on quite an identity wobbleboard here as we do this. And we have to balance our identity as teachers and the artistry involved in that with our role as lawyers, and that's really challenging. And if we break that down a bit further, the dimensions of expertise, and I could have broken it down even further than that, but you know, just looking at it briefly, can split out into several levels. We have the requirement to be supervisors. We're subject to regulation, like law firms. We have to be covered by professional negligence insurance and so on. So spontaneous creativity and breaking out the jazz band or the banjo, although we'd love to do it, isn't something we can unleash without constant awareness of those holding fences. We're also, Schön would suggest we should, modelling professional attributes. So we need to enact values and ethical behaviours we want our students to develop in our joint work with live clients. And we're, in doing that, as Sheldon observes, visible and accountable. We're traditional teachers. We're responsible for overall delivery of a learning experience and assessment of that experience. And we are hoping as well, because of our holistic emphasis in the new module, to be coaches too, supporting professional and personal development, enabling students to develop positive professional identities and become reflective practitioners. More or less there. So this is really an uncomfortable place in some ways for us to be. Our own professional identities as lawyers were not originally built on the model of reflective practice. It didn't exist when we trained. So we're having to develop all these skills along with the students. And during the process of designing the model, we've come up with an approach which we hope will support us with this challenge. So this is the practical suggestion at the end of all this. What we're going to do is draw on expertise from another area in our faculty, our business programme, Team Entrepreneurship, which is fully based on a coaching model, as students work in teams to set up businesses from day one of their degrees. Our coach is very experienced. She also has a law degree, although she's not practiced. And we focused on her working with the students initially. We wanted to use coaching as a way of helping them do that sense-making process and reflection on their experiences in a safe space that would separate that aspect, that holistic aspect, that emotional aspect from legal supervision of client work. However, the more we talked to her, the more we realised that as tutors, we could also benefit from the coaching approach, and that this could create a really valuable space for us to reflect and define our ongoing boundaries in relation to our coaching, particularly as we go through what we anticipate, what we know is going to be a really challenging and stressful first year for our clinic. You know, we didn't envisage setting it up in the middle of COVID. So our model, as the slide shows, therefore envisages her working with different configurations of students and with us as tutors outside the traditional teaching spaces, so that we can reflect privately with her. And this is going to, we hope, be a really interesting experience for all of us. It's going to take her coaching into a new place, so potentially expanding her expertise in a new direction while supporting us. So we start next Wednesday, and please wish us luck. Thank you very much. Let me just click on, just leave it on the slides for the last moment.
Thank you, Rachel.
Thank you. Sorry, really all the way through that, my blooming kitten was trying to break into the room. I could hear scrabbling at the door.
We haven't yet had our funny moment of today's presentation of anybody walking in the middle of a session.
No,
so thank you so much. This sounds.
I shut the door
so
because my son was singing and my blooming cat. So talking about all your identities, it's your other identities that you bring in from the house as well, isn't it?
And we have time for one question, and I think I might ask you about the identities actually, because you were talking about the different areas of expertise that the law education covers, and you've added the final thing, which is the personal development, the identity formation. And how you're taking your expertise along, but also potentially taking the expertise of the legal profession along in the long term. So how have you navigated being an expert in kind of law education and then becoming novice in this new way of approaching your teaching?
Well, I mean, I think that's the challenge for us now. We're not novices in clinical education. We've been doing it for a while, but in an extracurricular sense. But we haven't been doing it, you know, we haven't had to bring all these things into one place. So when we do it as an extracurricular activity, it's almost like we can just switch into lawyer mode and we can become lawyers. And because we're not having to get students, you know, we hope students will reflect, we encourage them to do it, but we're not having to be responsible for the whole package. So we sort of flick our identities over more into the lawyer identity, but actually having to do it in a teaching setting, in a, you know, where there's credit involved and all the rest of it. You know, on the one hand, we are out there with the general public. You know, we're not messing about here. This is not simulation, but we are still getting our students through assessments and so on. And I think I've drifted from your question, but that really balancing those things. I mean, we haven't done it yet. You know, we start doing it next week, but I think it's been really helpful to actually have the opportunity before we start to identify this. And I know that my clinic colleagues who've been navigating this perhaps more than me because they've had more experience over the last few years, particularly with family law, they very much feel like this issue of boundaries is something they're battling with all the time. So we're actually consciously focusing in on artistry and so on, I think is a really positive step for us. So that's been really good.
Thank you, Rachel.
Yeah, and Jane says,
couple...
I was just picking, are the learning aspects of the clinic reflected in the assessment, Rachel? Yes, what we've done for the students is we've identified a triangular kind of 3 learning dimensions. So we've looked at the professional dimension of learning in terms of, knowledge and skills in a legal setting. We've looked at personal development. We've actually made that an aspect of it. And then we've looked at wider development in terms of understanding the legal world and understanding law in practice and justice and so on. So the 3 dimensions together, we hope will help to support the students in developing this holistic approach. And again, we'll see if our model works.
It sounds really interesting and really impressive, and I think we'll look forward to hearing more next year about how it's gone.
Yeah, we'll have done it.
Thank you so much, Rachel, for your talk. It was really interesting.